glad to see you on your feet, Sir James, because I had a matter of housekeeping to raise with you.
Right.
We were looking previously at page 379 in the Bible.
371?
No, 379.
379, I'm so sorry, yes.
The explanatory notes relating to paragraph 1F.
Yes.
And you'll see that the first example given is a question relating to the making of orders in council.
Yes.
And it says, see note on section 118.
We don't have that.
Yes, it'd be helpful if you could provide us with that.
We certainly will, and my Lord, that was with the Lord Advocate's permission and apologies. I said I might come back and have a further think about section 54,
yes.
And I have done in the context of inter alia, page 379, which you've just drawn attention to. I think section 118, or for present purposes, what you need to know in relation to that example is that the making of an order in council by Her Majesty of that kind would be an act of, in effect, of the Scottish Government under section 118. And it was to that I wanted to return a little bit. If you just go back in the bundle to 322, back to the well-known words of the tailpiece and Schedule 6, paragraph 1F, it may be helpful just for the purpose of this analytically, just to put another number or two in there. So what I'm going to call F1, F Roman 1, runs from any other question about whether a function is exercisable within devolved competence or in or as regards Scotland, draw a line, and F2, any other question, because as my Lord pointed out, they're distinct categories, that's why it's any other. I mean, you could put an A and a B, if necessary, and it might be helpful for the purpose of understanding the explanatory notes to which we've just gone, put an A and a B, an A before within devolved competence, and a B before in or as regards Scotland. The point I wanted to draw attention to is that, and it may be that this has got home anyway, but in case it hadn't, is that all of the examples in the clip that we handed up this morning are examples falling within F2, i.e. the tailpiece, what I keep calling the tailpiece, and not F1. And that is because they all relate specifically to reserved matters as conditioning the powers, and only reserved matters as conditioning the powers, and they are to do with functions of the Scottish Parliament, to which devolved competence doesn't apply for obvious reasons, or UK ministers, to which again devolved competence doesn't apply. And devolved competence, as my Lord drew attention to, is a defined concept and dealt with in section 54. And so, as you will recall, although again I think this might have to go in the box marked section 118, and we'll provide you with a copy of that as well. But section 54 deals, as you will recall, in sub 2.
Remind me of the page number.
It's not, I'm afraid, in the bundles. It's one of the ones that the Lord President drew attention to, and we'll provide it to you. But sub 2 of 54, just for your note, deals with things being outside devolved competence when you're making, or it would be Scottish ministers would be making, because that's what devolved competence is about, making subordinate legislation. And sub 3 is about Scottish ministers exercising functions of any other kind, i.e. not making subordinate legislation. And in both cases, whether or not something is within or without devolved competence, see back to the words of paragraph F1A in my new numbering and lettering system, they're all controlled by the same competence things that control the competence of the Scottish Parliament to act. So they've effectively dragged over that competence concept from the Scottish Parliament and applied it to subordinate legislation and the exercise of functions by Scottish ministers. And so when you're looking at F1, the core points to bear in mind are that is all to do, in effect, with functions, whether delegated legislation or subordinate legislation or otherwise, of Scottish ministers. And perhaps unsurprisingly, given the definition of devolved competence in section 54, which we've just seen in 2 and 3, that is all controlled by competence. That's why the word is used in that way in F1. See, by contrast, what I call F2, i.e. the tailpiece, which only refers to reserved matters and is, for the reasons I've shown you in the little clip, all to do with UK ministerial power and its conditioning, and or conditioning on the powers of the Scottish Parliament in certain spheres, and therefore not within F1 and controlled by competence. This one is controlled by reserved matters, where that concept is specifically referred to as the moniker for control on the power.
So you started your explanation by saying that when making an order in council of that kind, and then you went on. So does the Scotland Act provide for making of orders in council of different kinds? I suppose at least that must include when an order is made to distribute matters under Schedule 5.
Yes, and I think it's to do with the transfer of, it can be to do with the transfer of functions and so on. But I think the 118 example it tells you that this example in this on 379 is an exercise of function by Scottish ministers.
I mean, 118.
I hope I got that right. I haven't got
118. It is concerned with the exercise by a member of the Scottish Executive within devolved competence. This is in the original statute, which is this is what the notes are commenting on. The exercise by a member of the Scottish Executive within devolved competence of a function to make, confirm or approve subordinate legislation. So there is no specific mention of orders in council, but I think orders in council fall within the definition of subordinate legislation.
I think they would.
So, and you tell us that the minister is regarded as making the order in council, notwithstanding that it's,
as it were, notionally, notwithstanding that it's Her Majesty for this purpose. I think that may be the effect of section 118. But the key point for present purposes is that all of these other examples, apart from the one that I referred you to this morning, i.e. the very tailpiece of those examples on 379, where the functions of a body relate to a reserved matter, all of the examples that are given before that are all within what I call F1.
yes.
Because they're either raising a question about devolved competence, which by definition is a matter engaging the exercise of power by Scottish ministers, or they're in or as regards Scotland. So F1B, if that makes sense.
Yes.
That shows that distinction is being deliberately drawn by the draftsman. And as I say, the core point I wanted to make, in case it was a question that was still live and floating as a result of the submissions this morning, was that all of the examples in the new little clip are all examples of specific references to reserved matters. They're not examples within F1, because by definition they're to do with acts and matters. All of these examples are to do with acts and matters of the Scottish Parliament and or UK ministers.
So are you saying that whereas this morning you were suggesting, well, perhaps they all fall within both, actually now you're saying they're mutually exclusive?
They do look as though they are, which is more consistent with the structure of it. So apologies if that impression was given. I think Lord Reid was testing that proposition this morning, and on reflection he's right to do so.
I'm just sorry to make sure I understand it. The first part of paragraph 1F, then you say is, and perhaps I've misunderstood this, restricted to subordinate legislation. Is it?
No, because Scottish ministers, the devolved competence issue can apply to Scottish ministers when making subordinate legislation under 54.2 and when making or when exercising other functions under 54.3. The point is that it's Scottish ministers, because devolved competence doesn't apply to the UK Parliament or to UK ministers, whereas reserved matters, i.e. F2, are referred to in the Act, and they all refer to the Acts of the Scottish Parliament and the UK ministers. So they all refer to the Acts of all the examples here refer to the Acts of either the the Scottish Parliament, or UK ministers. So they are discrete categories in that way, and I think Lord Reid was questioning that. He said any other question arising by virtue and so on. So, yes. And I'm effectively agreeing with that and explaining why. Yeah. But it does bear out and reinforce the point I was making this morning about the meaning that you give to reserved matters and arising by virtue of this Act about reserved matters in F2. I'm sorry, that's rather a convoluted way of going back.
Just following 54.3, it's in the case of any function other than a function of making, confirming, or approving subordinate legislation.
Yes. That is dealt with in
that's F2.
Yes.
It's outside devolved competence. If the legislation giving the function was outside the legislative competence of the Parliament.
Or would be, yes.
Or would be, yeah. And so what you're postulating there is some other legislation passed by the Scottish Parliament, and they're exercising a function under that other legislation.
I think that's the way in which 54.3 works. Yeah.
Yeah.
Yeah. Yeah. So it's different from their act of making subordinate legislation. It may be a narrow range of functions, but that's how they define whether it's within or without competence.
So the examples he gave us from the Scotland Act are all under that Act, as opposed to under other legislation passed by.
They're all under these are all under the Scotland Act. Yeah, exactly.
There is 54.2 dealing with where you have an act which is within competence, but the regulation or subordinate legislation making power is actually exercised in a way which is outside competence.
Or would be if it was put into an act of the Scottish Parliament.
54.3 is dealing with where the primary legislation is itself outside competence, then any subordinate legislation made under powers in that act are also outside competence.
I'm not sure. Is that bit right? Number 3 is in the case of any function other than a function of making or approving subordinate legislation. So it's cutting out the exercise of making subordinate legislation or things to do with that. So it's a broader set of functions than legislative, if that makes sense. And it's then defining the test of competence by reference to what would be the position were it to be done under an Act of the Scottish Parliament. So there's a hypothetical test of competence.
And in practice, the function might well be conferred by UK legislation.
Could be.
And in that event, the limits on devolved competence would only bite at the stage when the function was being exercised by a minister.
Yes. But I come back to the core point. And the core point is that, as was tested by Lord Reid this morning, F1 and F2 are about different things. To take it at its most simple, F1 is about the exercise of power by Scottish ministers, legislative or otherwise, or if something engages the question in or as regards Scotland, and F2 is exemplified by and applies to, as a separate category, in the examples I gave you in the little clip, to things done by the Scottish Parliament and all UK ministers.
So your F1 actually is 2 categories. Are you able to help us with the second limit there, or in or as regards Scotland? Does that marry up with some specific language in the Scotland Act?
Yes, there is. There are. I'm not sure I've got them here, but there are provisions that require certain matters to be in or as regards Scotland. I'm sure we can give you a little list of examples.
With the notes coming in, I think it would be useful to
see that. But it is a separate category. That's why I suggested putting A and B in there.
Yeah. Can I raise with you? I'll let you do it.
Yes. No. Sorry.
No, by all means, deal with the. Well, can I raise with you another way of looking at this? When the legislation when the Scotland Act was being drafted, it was necessary to draw up lists of devolved, of reserved matters, which we have in Schedule 5.
Yes.
And as we've we discussed earlier, sometimes they're very specific, other times they're much broader. And inevitably, questions were going to arise as to whether a particular subject fell within the scope of reserved matters or did not. And commonly, there are going to be disputes. I mean, this is something which the Lord Advocate may be able to comment on in due course, but it seems to me that commonly there would be disputes between the Scottish Government and the UK Government over the demarcation of responsibilities. And one would imagine this happens week in, week out. The issues in agriculture, trade and industry, road traffic, all sorts of areas where the view may be taken by the Scottish Government that this is something we can do, and the UK Government may take the opposite view. Now, very often they will be able, no doubt, to arrive at a solution by negotiation.
Quite.
Sometimes they might not be able to.
In which case you might need an order under Section 30.
There might be, it's not inconceivable that there might be an unwillingness to make a Section 30 order.
That's true too.
Now, in that kind of situation, there are in principle, there are two ways forward. One is to have some sort of arbitrator who can determine the issue. The other is to litigate, and or just to go ahead and wait for somebody to take proceedings against you. It occurs to me that 1F2, as we're calling it, might be designed as a means to enable the two governments to have demarcation disputes resolved.
My Lord, the difficulty I think with that, I don't want to go back over submissions I've made, the difficulty I think with that is that although of course reserved matters might be thought to be at the core of all of this, it doesn't provide a very good explanation as to why that wording is used in contradistinction to the word competencies in F1. For example, I know they're dealing with different things, but you've specifically referred to reserved matters, and there may be points of controversy between the Scottish Government and the Westminster Parliament about other matters that bear on competence under 29(2), for example.
Well, there might, but they might not be quite as sensitive.
And also, I mean, the dividing line between, if you like, the authority of the UK Parliament and the authority of the Scottish Parliament is the dividing line based around reserved matters. There may be disputes about the other things, but that's the division of authority between them.
Yes, they're both alike, obviously, bound by convention rights, insofar as those have a binding effect. When the legislation was being prepared, they would both have been bound by EU law. But those don't give rise, that's a common restriction that they're both under. They don't give rise to what I'm calling demarcation disputes, whereas reserved matters do.
And restrictions in Schedule 4. I mean, there are just certain difficulties with that. And if you say, and again, we discussed this before, a short adjournment, but if you say, well, that's the basic purpose, it's a really quite cool purpose. It means that whenever an issue of dispute about demarcation arises, you don't need to worry about any of the provisions that say, actually, this has got to reach a certain stage of fruition, it's got to go through the formalities. You can say at any stage that this issue has arisen in negotiation, we've asked you for Section 30 order, you're not doing it. Or we think that this means this, and the Westminster think that it means something else. If you can just go to the Supreme Court to produce that as an issue, the constitutional difficulty with that is it does suck the court into what might be either an advisory or a political process. And it prompts the question that I raised before the short adjournment as an issue with the Lord Advocate's cases, is where is the principled line? Yeah. At what point can you do that? When can you do it? Under what controls? Yeah. Which the answer may or may not be that it's sufficient to say we are a court and we've got discretion.
Yes. Well, in a constitutional statute of this kind, the view might rationally have been taken that if you entrust the power exclusively to the law officers, then you can be confident that references will only be made on a responsible basis where it's in the public interest, or that's the judgment of a public interest by the relevant government. And the long stop protection is the court's ability to protect itself by declining to get involved in the exercise of its discretion in matters which, for example, would be politically too sensitive.
My Lord, you might take that view, and I addressed that before the short adjournment as well. The difficulty potentially is that you end up with some pretty unwelcome consequences from the Lord Advocate's perspective about the stage at which other law officers on the opposing side of the argument might be able to refer inchoate legislative policy ideas of the Scottish Government to this court and demand an answer or ask for an answer subject to your discretion. And of course I recognise that the court has a discretion and can control to some extent. But the point I was really making, the principal point I was making before the short adjournment, was there are limits to that, and when a court is exercising a discretion, perhaps a fortiori a discretion which it has discovered, rather than having conferred expressly upon it under the Act, it will be very concerned to do so in accordance with the consistent and faithful treatment of the structure and content of the Act. And of course the only thing that we're really dealing with here are things or subject matter areas which are to do with draft bills, because that's the only point at which the Section 3111 problem arises. It's to do with having to make that statement. That's why we're here. So it's always linked to draft bills. And that direct link, which is what I entirely accept causes the legality issue that my Lord Lascelles was raising before the short adjournment, that only arises in relation to draft bills, and that does take one very, very close to the procedures that are set up very carefully under the Act that lead to the precise resolution. Now, of course, you will end up with some that don't get through the barrier.
Yes, I see that.
That's just a question of who takes the political and legal heat at what point under the structure of the Act.
The consequence of your submission is that if there is a disagreement, for example, over whether I don't know, the dimensions of widgets fall within reserved matters.
It matters not.
Then the Scottish Government would have to promote a bill, the Widgets Scotland Bill, and wait to see if the matter was then referred under Section 33 to this court, rather than the question whether widgets fall within reserved matters being taken to this court at a much earlier stage.
That's precisely the logic. And the Lord Advocate wouldn't have to wait for someone else to do that. Once it had reached that stage, she's one of the list of the law officers who can refer at that point. The real sting in the argument against me is to say that there will be some examples when the Lord Advocate or the person in charge of the bill, is unable to make the statements, as a result of which the Scottish Parliament will never get to debate widgets. And that I've sought to address in the manner that I've done. I'm sorry to reprise those submissions, but that's how we put it.
And so just taking one of your worked examples, then you refer to Section 23. And if I understand correctly, the worked example was 23, 1A and B, is that right? Or not? As a function. Or which one was
it? Parliament can require
any person.
It's a power of compulsion.
A power of compulsion. And you said that if you applied 1F...
if you then go to 23.6, you've got to next.
Yes.
So that function, where the functions of a body relate to reserved matters, that's the bit, the Parliament may not impose. So the power of the Scottish Parliament to issue that compulsion does not run in those circumstances. And so I say that fits within, if this was going to be your, well, perhaps I would let you ask your question.
No, within the sweep all clause at the end of...
Exactly so, and not within the first part.
And not within the first part. And then you postulate that you would then have a reference by the Lord Advocate in relation to whether it did or didn't relate to a reserved matter.
Yes, in relation to that.
In relation to that.
Exactly so.
And what's wrong with that?
Well, you can have these are devolution issues that can be referred under paragraph 34. So if they fall in the tailpiece, they can be referred as devolution issues.
Yeah.
And so if there was an issue about whether or not the functions of the body in question related to reserved matters under 23.6,
Yes.
that could be referred under 34. I've got no difficulty with that.
Right. Okay.
My argument is that that gives the meaning and the control, the limit to those tailpiece words. What the Lord Advocate has to do is to say, no, that goes more broadly. What that means is that you can refer the question whether I could make or I'm doubtful about making a Section 31 statement. My point is that this is a very specific reference to the sorts of examples that sit within the tailpiece of the wording. And all of those are examples that I've given you in the clip.
So if Parliament...
They relate only to UK ministers or the Scottish Parliament.
I do, because otherwise that's the distinction that's being drawn.
Extend to the powers of the Lord Advocate.
Yeah, they don't.
So what you envisage under 23 is that Parliament requires someone to produce the documents in his custody. That person says no, because all my functions relate to reserved matters, so I'm not going to produce
I'm
them.
UK, I'm not Scots.
Yeah, I'm not going to produce them, and
Yes.
there's then a standoff between
And then there'll be a
them,
standoff and
and
that
then
will be
there can
resolved.
be a reference of that issue
Yes.
to the...
And that would be the legitimate subject, to go back to Lord Stevens'
Yes.
question, that would be the legitimate subject of a reference under Para 34.
Why would it be why can't it just be a member of the Scottish government being required to, or why does it have to be a minister of the UK government? It's require any person. And
Yes, but these are Parliament's powers. These are powers of the Scottish Parliament.
yes,
And so it's reserving, it's saying the powers of the Scottish Parliament in one are controlled in this manner. So the focus is on whether it's the focus is on the nature of the power. It's a Scottish parliamentary power.
yes.
It isn't a ministerial power. So the fact that the body in question isn't one thing or another doesn't really matter. What matters is that this is a parliamentary power, just like the other powers are either parliamentary powers or they're powers of a UK minister.
I mean, it seems to be saying that the Scottish Parliament can't hold before it
UK bodies.
Yeah, who's exclusively UK.
Exactly so. But the point for present purposes is a parliamentary power. And I don't quibble with the idea that 34 could refer. Of course it could. The question is what that tells you about the meaning.
Would it be fair to say that the implication of your argument is that it's in 1F2, when it says any other question arising by virtue of this Act about reserved matters, the words by virtue of are really meaning expressly under a provision of this Act.
My Lord, they are when you read them with being about reserved matters and you look at the contrast between F1 and F2.
Yeah.
I'm a bit worried that my Lord will take that as being answered by the definition of by virtue in section 126.
No,
but that is it. That is it. It's referring to that concept as specifically referred to in the Act, and we've given you examples of where that's done.
Yes, I mean the broader view is really taking the view that the Act gives rise to a lot of questions about reserved matters.
It is.
But you're saying that's too broad an approach. There are specific provisions of the legislation which require, which refer specifically to reserved matters, and that's what this provision is about.
And you have to look at what that whole phrase in context, arising by virtue of this Act about reserved matters.
Yeah.
You look at it in the specific context of F1 as well, which is referring to competencies for obvious reason, and you look at it in the context of the inexplicability of saying, as my learned friend does in relation to section 31, not merely have you got the section 33 process which follows on the time sequence that we saw, but in relation to the section 31 power, the doubt about a Scottish statement or a statement by the person in charge of the bill about competence must include all the matters in 29.2.
Yes. Yes,
Otherwise it doesn't make any sense.
So you say the Act confers limited powers on a variety of institutions, and the first part of 1F is concerned with the limited powers of the bodies exercising devolved competence, and the latter part of 1F is concerned with other institutions whose powers are defined by reference to reserved matters.
Yes, exactly.
And how does that fit in with your submissions about paragraph 4 of Schedule 6, which is at 326? Do you say that kind of question about whether the person has to produce the documents under section 23(1) if required by Parliament, that is something that doesn't have to come here, it can go to the Court of Session?
You can under that procedure. And that again makes sense, it might be thought, because that's to do with that's not to do with draft bills and section 33 and matters at the top of that legislative, as it were, hierarchy, which comes straight to this court. I hesitate to describe them as second-order issues, but they're issues which might benefit, as it were, from that resolution process ultimately coming here, not coming here direct as a court of original jurisdiction. That's it.
Do I discern your argument to be that Section 31 refers to legislative competence and therefore doesn't refer to reserved matters and therefore doesn't fall within paragraph 1F? Or are you accepting that Section 31 has to be read with Section 29 and it does refer to reserved matters?
My submission is that Section 31(1) does require a statement to be made about legislative competence. Legislative competence is a defined term, and it includes all of the categories in 29 sub 2, and therefore it can include reserved matters, but it covers broader things. When you get then into section or paragraph 1F, you've got the things being split out. And the only reference in the tailpiece is to reserved matters, which is one of the subcategories of competence.
Yeah. I mean, this I think is really repeating a point that Lord Lloyd-Jones made. The consequence is that that while F2, as you say, is concerned with bodies whose powers are defined by reference to reserved matters, one body whose powers are evidently so defined is the Scottish Parliament, but it wouldn't fall within those closing words on your submission so far as its legislative functions are concerned, but it would in respect of other functions under the Act, of which the one example we found is its power to call witnesses and require the production of documents.
Yeah, that's one example. Exactly so.
So, am I understanding it correctly, then, that you say that within F there are two mutually exclusive categories?
Yes.
And you base that submission on the word other,
And on the reference solely to reserved matters in that way.
And on the reference solely to reserved matters. Is it relevant to your submission that the word other also appears right at the start of F, in the first category, the first subcategory? So any other question about whether a function is exercisable within devolved competence, is that not, and then the word other appears again, is the word other in each case not distinguishing what's gone before in A to E as opposed to the word in the second part of F distinguishing what's appeared in the first part of F?
To which I'm not sure what the answer to that is. Certainly F1 must be referring to points of distinction with what has gone before in paragraph in particular 1C. It's a little difficult to see how 1C marries up with the first wording, i.e. F1A. If you want a philosophical teaser, you might think about that. Not sure we come up with a very good answer to that question. But whether one can go further and say, therefore, the other thing must be doing the same thing, I'm not sure.
All right.
You still use the word.
But your submission depends on them being mutually exclusive categories. Yeah.
But I thought that was more to do with the definition of devolved competence and
What, F1?
the fact that they don't cover the same material, F1 and F2.
It's in part to do with that, in large part to do with that, because devolved competence only applies to ministers in that way, Scottish executive in that way.
Well, as I understood it, the point of a question is that questions can arise by virtue of this Act about reserved matters under A to E. And F catches any other question arising by virtue of this Act about...
Well, my Lord, I can perfectly contentedly live with that. Mm-hmm. That doesn't damage my argument, I respectfully submit, because, for example, you have in A actual enacted acts of the Scottish Parliament, so once it's gone through, and you have in the bits that I referred to earlier on, proposed things in B, C and D. So I'm not sure I'd accept, if this is the purport of the question, that damages the distinction that I draw.
Well, if it's right, it would mean that arising by virtue of this Act would have a wider connotation.
Well, it's still got to be about reserved matters.
Yeah.
And if it adds to A to E, so be it. The distinction that is drawn, particularly bearing in mind that reserved matters is only referred to as a separate concept in the tail piece in F2, still have to be taken into account and given a full force and meaning and effect.
Yeah.
So even if it's intended to add to A, B, C and D and E, I'm not sure that touches the basic point I make, which is that there are two different things being dealt with in F1 and F2 for the reasons I indicated. And the only way of actually making sense of all of this is to try and identify where the Act has referred to reserved matters as an isolated concept and have a think about that.
But, sorry, just to press, I think I'm pressing on the same point. I mean, doesn't it make a difference which the comparator is for the purposes of the other that's being compared? So true it is that you've got two limbs to F, but the first limb must be comparing what is expressed there with what has gone before. And one can see, for example, at C, that could cover the same ground to an extent, but there may be an additional residue. So the comparison must, for the first other, be between A to E and whatever residue might fall within F. As I've understood the points being put to you, and I just want to make sure that I've understood your answer. If one reads the words "and any other question" in the second part of F, interpreting the word "other" in the same sense as in the first part, then the contradistinction is not with the first part of F, but with A to E again, as it is for the first part.
Well, yes, and I've said it, I hope fairly, I accept that. That's a perfectly coherent reading of it because the same word is being used, which is other, but you've still got to grapple with the remainders of the concept in the provision, and it isn't illegitimate to try to compare F1 and F2. And even if you say, well, that gives a broader meaning to arising by virtue of this Act, because you're doing a comparison with A through E, you've still got to grapple with the incoherence on my learned friend's case, which is ultimately what this is about, which ties it back to Section 31, and what Section 31 is doing, and doubts about Section 31, at which point, if it covers that, why is reserved matters only referred to, when competences could create the very doubt that would not enable a statement to be made? So ultimately, I can live with my Lord Jones's point, which says, well, do the comparison with other, and that may lead to as it were, a slightly broader or differently focused purpose of comparison. But you've still got to grapple with the remainder of it, and in particular, you've got to grapple with what reserved matters means, referred to as an isolated concept.
That reading, if correct, of course, that reading would deprive you of the argument that there are mutually exclusive categories. But it wouldn't deprive you of the alternative argument based upon the second limb being limited to reserved matters.
My Lord, yes, I think that's fair. I think that's fair as a matter of logic.
But just on the second limb then, I can see that you've identified for us certain points in the Scotland Act where something doesn't fall within devolved competence, so isn't swept up in the first limb, and therefore, if you've got a sweep-up provision, you need to capture it in the second limb. And I can see that there are some functions like that which are where the words are expressly used, talking about the boundary being reserved matters. But in a sense, it might be said that the question of introduction of the bill also could be read as falling within that category. It's true the express language isn't used there, but nor is it something which falls within something which is exercisable within devolved competence, because it's a function of a parliamentarian, if you like, in the operation of the proceedings in the Scottish Parliament. So if the relevant divide is between things which are the residue within the devolved competence category and things which are in the residue of the about reserved matters category, could it not be said, unless you pin that last category to the specific language each time it's used, that in fact what we're talking about does fall within that latter category?
Well, I say you have to pin it to the exact language. Right. That's the only coherent explanation for why the last two words are used.
Okay.
And particularly when you get to section 31, where the statement that is required to be made is a statement about competence.
Because you say this shouldn't be swept up in either F1 or F2 because it's dealt with in section 33 exclusively.
Yes, and in fairness, and I do take the point of it that Lloyd Jones is putting to me, which is if you can view these as being, as it were, referring to a comparator in the earlier part of paragraph 1, and to some extent, I say so be it to that, and you've still got to do reserved matters, you've still got to have a think about that, why are they there? But even if that is the prime point of comparison, you've still got a comparison that is inherent within F itself. And that may be of some interest when you're trying to work out what the right interpretation is. I accept that none of this is easy. but I do submit that it is quite a stretch and quite a cut across to say the consequence of this is that whenever a Scottish minister or a person presenting a bill has a bit of doubt about whether something is within competence, they can simply turn around and say, well, subject only to the discretion of the Supreme Court to control its own procedure. I can avoid section 33 and I can go and ask the Supreme Court for advice about whether or not, if I wanted to introduce this legislation, it would be good, bad or indifferent. They could turn up and say, I'm thinking of doing it in this way, but I might want to do it in that way. Which do you reckon is better? There's got to be some control on it, and that involves, to some extent, I quite understand why we've gone into the interstices of the language and how the comparators might work and all the rest of it, but to some extent it involves a stand-back exercise to see what the Act is actually trying to do, and constitutionally, what controls it's actually trying to impose before this court's original jurisdiction is engaged. Tempted to say rien ne vint plus, but well, I'm grateful.
Yes. Thank you very much, Sir James.
For submitting in that time.
Yes, Lord Advocate.
Yes, thank you, my lords, my lady. As a preliminary matter, I can confirm to the court that I've provided and to the Advocate General's team a note setting out the role of the Lord Advocate and other law officers at stage 3 of the passage on legislation in the Scottish Parliament. So I think that was something that we touched on yesterday. And I've also provided section 67, section 63 and schedule 7 to the court and to the Advocate General's team, and the note that I was asked to provide in relation to the procedure in relation to private members' bills. So,
and the first of those items was essentially a description of how bills pass through the Parliament.
That's correct.
I'm not sure I've got that.
Well, if,
I mean,
well,
we got a clip this morning with, let me see, we had 3 documents in it. One was Schedule 7. One was Section 63, and the third was the note on challenges to members' bills.
yes, very well. I think that what is missing from that then is the issue around stage 3 passage of the legislation in the
Yes.
Scottish Parliament. That can be, that's just been missed off the list of things that you've been given, my Lord.
Is that note on challenges to members' bills in the Scottish Parliament?
Yeah. Is it the same thing, a different? So it's the same thing, it's a different label. Yeah.
Oh.
It's in the folder, in the bundle in the...
Do from the bottom.
So it's just, there's the same thing in this one document. That's perhaps.
Yes, I've got note on challenges to members' bills in the Scottish Parliament, which appeared as the penultimate item in the folder, so far as I could see.
I think that, so that's everything, I think.
Oh, I see. It's page 4 of that document. It's simply the relevant rule in the standing orders.
Yes, that's so, Lord. Right. So I wish to begin my response to Sir James Eadie's submission about the bringing of this reference and the consequences for this court, should it accept my submissions that the court has jurisdiction to determine the reference. First, I want to emphasise what I've said in the reference in my case and in my oral submissions, that this reference has been brought responsibly and after careful consideration as to whether it was appropriate to do so in terms of paragraph 34 of Schedule 1 to the Scotland Act. Second, as I hope would be obvious to this court, the reference has been brought not because the issue is trivial or one that's been raised on a whim or willy-nilly, I suppose, is one of the phrases that was used yesterday, but as noted by the President, that it is a matter of the utmost constitutional importance. Thirdly, Sir James made submissions that were to the effect that if this court were to accept jurisdiction in this reference, there's a prospect of that opening the floodgates. I simply observe that the power to make a reference is one that is conferred on law officers who can be assumed to exercise the function responsibly. I also observe that the court may have regard to the reality of the situation. And the reality here is that I have used the power to make this reference as Lord Advocate, and it is the first reference since the beginning of devolution. So how one might test the floodgates argument might lie in the reality of the situation. This is the first such reference in the history of devolution. Finally, on the practicalities of matters, there was some suggestion and discussion that because a Section 31 statement is made by a minister, the role of the Lord Advocate is somewhat remote to that of the minister making a statement, and that the minister in charge of the bill might obtain their legal advice from a source other than the law officers. I have two things to say about that. Firstly, as a matter of practicality, it is wholly unrealistic. It would be both unlikely and undesirable for ministers in the Scottish Government to seek legal advice on issues of competence in circumstances in which the law officers are the principal legal advisors to the Scottish Government and indeed are ministers in that government. Secondly, and in any event, the answer lies in the ordinary principles of public law. The minister must act rationally and in good faith, and must inform themselves by taking legal advice. Next, in relation to Sir James's reference to this court in relation to several judicial review claims that have emphasised that the fact that the courts will not give advisory rulings before a concrete legal issue has been crystallised, he submitted that this was the backdrop against which Parliament legislated in terms of Section 33. And I would make a number of points in response to that. Firstly, one should treat with caution the submission that Parliament has legislated against the backdrop, as Sir James put it, of the cases he cited to this court, or any specific principles of the common law, since the cases cited by Sir James all post-date the Act. Secondly, it is clear that in any event that Parliament intended to create an unusual mechanism for obtaining judicial determinations on issues arising under the Scotland Act that is very different from ordinary legal proceedings. In my submission, there's no reason to accept Sir James's submission that Parliament thereby intended to create a narrow, heavily circumscribed or restricted jurisdiction. On the contrary, paragraph 1F of Schedule 6, read with paragraph 34 of Schedule 6, demonstrates an intention on the part of Parliament to create a jurisdiction for law officers to refer questions to this court about reserved matters of the broadest amplitude. The only limitation on that power is that the issue has not arisen in legal proceedings. This is the express limitation within paragraph 34. Had Parliament wanted to create a more circumscribed power, it could have done so. On the contrary, it was the intention to create a sweep-up provision that ensured no issues about reserved matters could arise that were not in principle capable of being referred by a law officer to this court.
Why not sweep up other aspects of legal competence?
Simply by the fact that the issues in relation to other legal competence haven't been swept up doesn't mean to say that issues about reserved matters shouldn't be. And it was really, one can only imagine or try to understand what the legislature were about. But the import of reserved matters was one that was something that law officers of the day had to have in mind at the highest level in relation to all of the functions that they provide in advice to the Scottish Government. So reserved matters was a key issue for the law officers of the day in this particular case, and it's of the highest importance when one has regard to the operation of the Scotland Act. So the fact that there was a distinction doesn't mean to say that means that the reserved matters aren't available for consideration by this court. This distinction was made. One can only try and work out why that is, but that doesn't mean to say that the provisions of Schedule 6, paragraph 1F, don't entitle any other question arising by virtue of the Act about reserved matters for being referred under Schedule 6, paragraph 34. And Schedule 6, paragraph 1, is very broad in its terms, and it is broad in nature. And the first point to think about is how one looks at it. It's wrong to use simply the prism of paragraph 34 under Schedule 6 to try and understand what the purpose and the parameters are of paragraph 1 to Schedule 6. It's very broad in nature, and the breadth of it in terms of what's set down in paragraph 1A through to E informs ultimately the breadth of the the provision of paragraph 1F. So if we have a look again at electronic folder page number 322, and we look again at Schedule 6, paragraph 1, we can see the definition of the devolution issue there. And in relation to 1A, it means a question whether an act of the Scottish Parliament or any provision of an act of the Scottish Parliament is within the legislative competence of the Parliament. It also relates to a question whether any function, being a function which any person has purported or is purporting to exercise, is a function of the Scottish ministers, the First Minister or the Lord Advocate. It also covers a question whether the purported or purported exercise of a function by a member of the Scottish Government is or would be within devolved competence. It also relates to a question whether a purported or purported exercise of a function by the Scottish Parliament, the Scottish Government, is or would be incompatible with any of the Convention rights. It covers a question whether a failure to act by a member of the Scottish Government is incompatible with any Convention rights. And in relation to F, or any other question about whether a function is exercisable within devolved competence, or in or regards Scotland, any other question arising by virtue of this Act about reserved matters. Schedule 6, paragraph 1F, is not limited to any extent, particularly it's in the context of what we're dealing with here. It's certainly not limited or circumscribed by to any effect by the reference to any other sections of the Scotland Act. And it is broad in its amplitude in order to provide the sort of innovative procedures that the legislature had in mind when this Act was implemented. And I've touched on the rationale and the reasoning behind the Scotland Act in my opening remarks here. So to look too narrowly at Schedule 6, paragraph 1F, particularly in relation to the reference to and any other question arising by virtue of this Act about reserved matters, would be to restrict the amplitude of Schedule 6, paragraph 1F in a way that Parliament simply didn't intend. There are also, in my respectful submission, some important matters to deal with in relation to the explanatory note, and also in relation to the way in which the Act operates in practice in the courts throughout Scotland when we're dealing with devolution issues and reserved matters under the Act. Can I turn firstly to the explanatory note, which Sir James drew this court's attention to. And the explanatory note is at page 379 of the electronic folder. It is important to have regard to the full content of that explanatory note so far as it relates to subparagraph F, Schedule 6, paragraph 1, and the question of what is or not a devolution issue. So it says this, subparagraph F, any other question about whether a function is exercisable within devolved competence or in or as regards Scotland, and any other question arising by virtue of the Scotland Act about reserved matters. So the opening phrase is consistent with what explaining about the way in which Schedule 6, paragraph 1F operates. So it's entirely consistent with that. It then says this, the question swept up into the subparagraph can arise in various circumstances. There's no delimitation there or listing of where these particular issues might arise under the Act. It goes on to say this, for example, there could be a question about whether Her Majesty is making an order in council within devolved competence, see note on section 188, or whether a function is exercisable in or regards Scotland, so that it may transfer an order under Section 63, and we know Section 63 relates to the transfer of further functions to Scottish ministers, or whether a public body is a Scottish public authority whose functions are exercisable only in or regard Scotland. See definition in Section 126 on whether the functions of a body relate to a reserved matter. See Section 1263. So I say that the explanatory note referred to by Sir James suggests that a reference might be made in relation to the making of an order under Section 63. Section 63 is about the transfer of executive functions. So the explanatory note might equally have referred to a Section 30 order. A Section 30 order can be made to change Schedule 5 in relation to reserved matters. So there's no reason why it couldn't refer the question whether Section 30 order is required to establish whether the matter is or is not already reserved. So if a Section 30 order...
Sorry, what would be the point of that? I mean, if one's looking at a Section 30...
So if one's looking at a Section 30 order...
Isn't that the order that distributes matters between the UK government and the Scottish Government by potentially amending Schedule 5?
That's right, that's right. And the Section 30 order was obtained in order to permit, as was at that stage seen as the gold standard of legality in relation to the first referendum.
Right.
Yeah.
But why would you need, if there is a proposal to legislate, to make it clear that some matter either is or isn't a reserved matter? I can't see what would be the point in having litigation about that.
Well, I think the question is whether or not the issue is a reserved matter. And the question that would be before, for example, those involved in determining whether or not to make a Section 63 order or to make a Section 30 order, the question would be, is it required to establish whether the matter is or not already reserved? So you would...
Why do you need to know that? I mean, you're going to make an order which puts it beyond any doubt.
I understand that, but you're informing yourself as to whether or not the order is necessary. That's the point. So you might... The point is, these orders are required in order to ensure that a function that is reserved is passed over to a Scottish minister. So that would be a Section 63 order. Or you would need the order under Section 30 in relation to, for example, an alteration to Schedule 5 to ensure that an act that would be considered to be without competence in relation to a reserved matter would be necessary. The question might be asked, do we need that? Is it a reserved matter? So if you can refer a reserved matter over the competence or necessity of a Section 63 or Section 30 order, it doesn't make any sense then when you look at the terms of Section paragraph 1F that you couldn't refer the same sort of issue, an equivalent issue, under Part 2 of 1F, which is any other issue arising by virtue of the Act, which is what we are proposing. We are pushing forward in terms of this reference.
I wonder if I might give or put to you an example which might illustrate the point you're making. When the Section 30 order was made to enable the 2014 referendum to take place, it was made under subsection 2 of Section 30, which is the modification of Schedule 5.
That's right.
So as to to modify Schedule 5, and so and it did that by inserting a new heading into Schedule 5, which covered the 2014 referendum.
Yes.
Now, we see how the current political issue has generated these proceedings.
Yes.
An alternative form of proceedings might have been to well, I wonder, but what's in my mind is if the one might have challenged the UK government's insistence that a Section 30 order was necessary as being based on an error of law, and sought to judicially review it. Now, the issue in those judicial review proceedings would have been whether the holding of a referendum was a reserved matter.
Yes.
And I meant, on your argument, you would say that would have been a matter which could be raised in proceedings under paragraph 4 or referred to this court under paragraph 34.
Yes, that's so. That's exactly my point, is that if one looks at the explanatory note and understands what that's saying, then exactly the point my Lord makes is that, and so if one then applies that reasoning to why we're here and why I say it falls under paragraph 1A, one could see the logic in the position that I'm adopting before the court. So the explanatory note suggests that the law officers could have referred the 2013 order to ask essentially the same question that we are asking. So it doesn't, Sir James's whole analysis falls apart if one approaches it in the way that I suggest. So the next point that I wanted to raise with the court relates to an issue aptly described by the President, in this case as when he described this court as having a constitutional jurisdiction. We agree with this characterisation, and in my speaking note on jurisdiction and discretion at paragraph 39, I referred on this point to the case reference secession of Quebec, which I referred to at paragraph 39 of my note on jurisdiction, and at that point I only limited what I had to say to paragraph 25 in my note. But I think, in my respectful submission, the point is worth referring in a little more detail, and so I'd like to refer the court to the wider passage of that judgment from paragraph 24 onwards, and because it is relevant ultimately to some of the issues that this court's dealing with. So might I refer to the reference secession of Quebec case, and it's in the supplementary bundle of authorities, which was lodged by the SNP intervention, and the paragraphs that I would like to look at begin at page 818 of the electronic folder and go through to page 820. So the paragraph begins paragraph 24 on page 818, and I'd wish to read from there through to the end of paragraph 28.
I just missed the paragraph number.
So I'm reading from paragraph 24 through to the end of paragraph 28.
Now, we haven't looked at this until now, so if there are issues arising in relation to it, yes, on which Sir James needs to reply, I'll give him that opportunity.
Yes, thank you, Lord. So under the heading of justiciability, the court said it is submitted that even if the court has jurisdiction over the questions referred, the questions themselves are not justiciable. Three main arguments are raised in this regard. The questions are not justiciable because they are too theoretical or speculative. The questions are not justiciable because they are political in nature. The questions are not yet ripe for judicial consideration. In the context of a reference, the court, rather than acting in its traditional adjudicative function, is acting in an advisory capacity. The very fact that the court may be asked hypothetical questions in a reference, such as the constitutionality of proposed legislation, engages the court in an exercise it would never entertain in the context of litigation. No matter how closely the procedure on a reference may mirror the litigation process, a reference doesn't engage the court in a disposition of rights. For the same reason, the court may deal on a reference with issues that might otherwise be considered not yet ripe for decision. Though a reference differs from the court's usual adjudicative function, the court should not, even in the context of a reference, entertain questions that would be inappropriate to answer. However, given the very nature of a reference, the question of the appropriateness of answering a question should not focus on whether the dispute is formally adversarial or whether it disposes of cognizable rights. Rather, it should consider whether the dispute is appropriately addressed by the court of law. As we stated in Reference re Canada Assistance Plan, while there may be many reasons why a question is non-justiciable, in this appeal, the Attorney General of Canada submitted that to answer the questions would draw the court into a political controversy and involve it in the legislative process. In exercising its discretion whether to determine a matter that is alleged to be non-justiciable, the court's primary concern is to retain its proper role within the constitutional framework of our democratic form of government. In considering its appropriate role, the court must determine whether the question is purely political in nature and should therefore be determined in another forum, or whether it has a sufficient legal component to warrant the intervention of the judicial branch. Thus, the circumstances in which the court may decline to answer a reference question on the basis of non-justiciability include: if to do so would take the court beyond its own assessment of its proper role in the constitutional framework or of our democratic form of government, or if the court could not give an answer that lies within its area of expertise, the interpretation of law. As to the proper role of the court, it is important to underline, contrary to the submission of the amicus curiae, that the questions posed in this reference do not ask the court to usurp any democratic decision that the people of Quebec may be called upon to make. The questions posed by the Governor in Council, as we interpret them, are strictly limited to aspects of the legal framework in which that democratic decision is to be taken. The attempted analogy with the US political questions doctrine therefore has no application. The legal framework having been clarified, it will be for the population of the Quebec, acting through the political process, to decide whether or not to pursue secession. As will be seen, the legal framework involves the rights and obligations of Canadians who live outside the province of Quebec, as well as those who live within Quebec. As to the legal nature of the questions posed, if the court is of the opinion that it's being asked a question with a significant extra legal component, it may interpret the question so as to answer only its legal aspects. If that is not possible, the court may decline to answer the question. In the present reference, the question may be clearly interpreted as directed to legal issues. So interpreted, the court is in a position to answer them. I don't need to make reference to any other part of that. So I'm really drawing the distinction between a litigation process that the courts are so familiar with, as opposed to a reference process, and the constitutional role of the court in that respect, and one in which we say is directly analogous to the reference procedure that we are seeking the court's answer to in this particular case. So it's a different function, but we do raise legitimate, important, and constitutionally crucially important questions for not only Scotland, but for the whole of the United Kingdom. And it's entirely appropriate that this court, the Supreme Court of this country, deals with this issue. And that's really the thrust of what I would wish to take from this case. And that's the sole reference that I make to this particular case in this reference before this court. The final issue that I'd wish to touch on in my response is the point about the issue of law in this case. And I only seek to emphasise this, that the issue of law referred to this court has crystallised because it is an issue that I and the Minister seeking to introduce the draft bill have to ask and answer now. As I made clear in the reference to this court, and it can be seen at electronic page 5, the whole reason for this reference was the First Minister of Scotland recognised that all it should be done in Scotland is a legally piece of legislation, a legally sound piece of legislation is introduced to the Scottish Parliament. That's all that's being asked for guidance on that particular issue. And as I said in paragraph 2 on electronic folder page number 5, the First Minister recognised that the question of whether a bill providing for an advisory referendum on independence related to a reserved matter was contested. It was she who asked the Lord Advocate, the law officer of the country, to consider making a reference under paragraph 34 of Schedule 6. So it was on request of the Minister that the references was considered by me, independently of government, in accordance with the retained function that I've been given under the Scotland Act. And it was after having given the matter detailed consideration that I decided to make this reference. And
are those points going to our discretion, or are they an answer to Sir James' points about, well, what is the trigger? What is the starting moment from which, as you just put it, the power is to make this reference is crystallised?
Right. So I think it goes to the second point that my lady made. And I think Sir James was suggesting that things were to be done willy-nilly, that just when something popped into somebody's head, that they would make a reference. And it's to belittle, it's to minimise the enormity of the issue that's being brought to this court. And it's to determine, to show that the issue is not academic. It's crystallised. It's a real issue that has been a festering issue since the days of devolution. And in this context, we've taken the correct constitutional role in bringing this matter for a reference. And Sir James's characterisation of what is involved here is unfair. That's the point I'm making. It's just not right that he should say what he said about why we're here. It's so unfair. And it's reflected in everything that we've put forward in our case. And the trigger is the First Minister of Scotland, because she recognised the importance of the issue and the importance of making sure that everything's done legally, asked that I, as law officer of the day, took the consideration as to whether or not a reference was appropriate. Now, it may be that a different law officer would take a different approach on a different day. And I don't pretend that I'll only ever be the only law officer from now until the end of time. Of course, I'm merely a custodian of the office for a very short period of time in history. But what we know is that in the history of cases that come before this court, lawyers win cases they think they're going to lose, and lose cases they think they're going to win. And when they're very clearly, carefully balanced legal arguments that really can't allow a minister in charge of a bill to make the positive statement that's necessary in this case, the constitutionally right thing to do for the law officer of the day is to bring this issue to the court, and that's what's been done. And so I wouldn't wish to make any other response.
Well, thank you very much, Lord Advocate. Sir James, anything arising from the Quebec case? No. Well, we're most grateful to Council and no doubt those sitting alongside them and behind them for the submissions that we've received. As I said at the outset, we'll require time to consider what we've heard and what we'll be reading. But we appreciate the importance of this, and we'll let you have our judgment as soon as we can. The court will adjourn.